Let's get to the docket today. Josh Duggar, that's right, rhymes with hugger. It's certainly not pronounced Duggar. We certainly learned that, didn't we? Anyway, for those of you who are not familiar, Josh Duggar is in fact a former reality TV star. He grew up on 19 and counting. Well, now he's 33 years old. He's had a little bit of trouble in the family. I think he's going to get the label black sheep here pretty soon because he's certainly not staying out of trouble. As you may note, he had a couple of allegations made against him by his sisters long ago that he may have done something inappropriate. The family apparently has acknowledged it, and they're moving on. All right. Well, now, like I said, we brought you this information a couple of weeks ago. Old Josh was arrested and charged with receiving and possessing child pornography. He's currently out on bond. He has conditions related to his release. One of those are that he obviously has to have an ankle monitor. He cannot be around anyone under the age of 18 except his own children and only when supervised by his wife. And finally, he can't reside anywhere other than the residence that was approved by the court, which turns out to be some family friends related to Josh's parents. Now, they had a little incident. They apparently have called 911 at some point, and they said that they don't feel comfortable with the situation right now because they believe that people are basically hanging out by their house and it's making them feel uncomfortable. Their words specifically were they no longer feel safe. And that was one day after old Josh moved into the neighborhood. All right. So let's talk about what kind of sentence Josh Duggar is going to receive. Now, we give Mr. Duggar the complete and absolute presumption of innocence. And that presumption of innocence will, in fact, remain with him throughout and until the prosecution can prove their case beyond a reasonable doubt, unanimously to a jury of 12 people, or unless he pleads guilty. So now we have presented this, but we have the indictment here as it relates to Josh Duggar. He has one count of receipt of child pornography. He also has one count of possession of child pornography. Now, what I'm going to do is basically kind of outline the conversation that his attorney is going to have with him. More than likely, the United States attorney has probably sent over, or there's been some communication regarding a plea offer in this particular case. There's a trial date currently scheduled in July. That may get moved back depending on whether the defense moves for a motion for an ends of justice continuance so that they have time, sufficient time, to go through the evidence, look at it, analyze it, see what motions practice they would need to engage in, and whether they need a further time to get to trial. Now, anytime under the federal sentencing guidelines, that's the biggest thing that you have to consider in a federal case, all right? So each count here, receipt of the child pornography and the possession of child pornography, more than likely the United States attorneys would offer a plea to one count. Say, for example, receipt of child pornography. Then you say, well, Scott, what is the maximum penalty going to be for these charges? Well, so the maximum penalty on count one is not less than 5 years and up to 20 years. Obviously, 20 years is a long time. So at some point, the defendant, Mr. Duggar, is going to have to decide whether he takes a plea and whether he goes to trial. Now, certainly, if he's innocent, he should probably go to trial. Our system of justice does not necessarily like people pleading guilty to crimes they didn't commit, particularly to get out of jail. And here's the thing. Mr. Duggar is in federal court. He is not going to get probation, okay? When you go in federal court, there are very few crimes that make probation a possibility. Chances are, I'd say 99%, you are going to the Federal Bureau of Prisons. All right, how do we get to that number? Well, under 18 United States Code 3355A, which are basically the principles of sentencing in a federal case, one of the first things that the court has to look at is where does this crime come out on the federal sentencing guidelines? All right, so the first thing we have to do is take a look at the federal sentencing guidelines. And one of the most important documents in the entire book, which is rather thick, is the sentencing table. And you say, well, what does that mean? Well, let's explain. Each federal crime is given an offense level, and I'll explain that more in greater detail. Each federal crime is given an offense level, and then there's certain calculations that go from there. And then you have one's criminal history across the top. As you can see, if you're a criminal history category 0 or 1, let's just randomly pick an offense level, say 23, you're at 46 to 57 months. But if you have a terrible criminal history, it makes sense that if you are getting in more and more trouble, you shouldn't be receiving less punishment for committing crimes. Kind of goes against the whole principle of sentencing. So as you can see, I randomly picked level 23, no criminal history whatsoever. The possible penalty is 46 to 57 months. If you go all the way across the other side over here, it's 92 to 115 months. Well, what's a criminal history point? It's a conviction. It could be something as simple as traffic. It could be felonies. It depends how much time you served in custody. Was it a juvenile matter? You get extra points if you're released from prison or county jail, depending on the length of the sentence, and you get in additional trouble. So it moves you up across the top. It can move you up across the top of the federal sentencing guidelines. So let's take a look at Mr. Duggar. For his offense, 18 United States Code 2252A, it's a base offense level. He starts off at a level 22. Now, you may recall there was some information that came out at the preliminary hearing, and that was being presented to keep Mr. Duggar in custody. But these are things that the United States Attorney already knows. So under the federal sentencing guidelines, it says, first, is the defendant's conduct was limited to the receipt or solicitation of material involving the sexual exploitation of a minor, and the defendant did not intend to traffic or distribute such material, you get a 2-level reduction. So he goes down to a level 20. All right, but hold on. And it came out at the preliminary hearing that there were photographs or videos that involved prepubescent minors or a minor who had not attained the age of 12 years of age. Guess what? You go up 2 points. So you go from a 20, you're back to a 22. Then there's another section under the sentencing guidelines that you have to consider. It says, did the offense material portray sadistic or masochistic conduct or other depictions of violence or sexual abuse or exploitation of an infant or a toddler? I recall hearing testimony regarding that there were infants there. So guess what? You go up 4 levels. So 22, now all of a sudden you're a 26. As you can see, the punishment's getting higher already. Next question under the guidelines. The offense involved the use of a computer or an interactive computer service for the possession, transmission, receipt, or distribution of the material. What does that mean? You used a computer. Oh, guess what? Add 2 more points. So now you're at a 28. We also heard that there were a number of images, right? I recall hearing 200 plus images. All of a sudden, now you're at 28. Now you're up to level 31. Not looking good right there. So this is a guideline calculation that one could use if Mr. Duggar went to trial and lost. And the counts would basically merge because they're really the same stuff. So it really doesn't matter. So if he goes to trial and he were to lose, his guideline sentencing range would start at 108 months, right? What is that? 12 times 9, 108, right? About 9 years to 135. You can do the math, about 10 and a half. It can also go as high as 235 months, which is the maximum. And in theory, the court could always give him that because the maximum penalty is up to 20 years. However, if Mr. Duggar were to enter a plea of guilty, he would receive 2 points for acceptance of responsibility, which would take him down to offense level 29. And offense level 29 is right there. Now, I'm not aware of any criminal conduct where Mr. Duggar has had any convictions, and I don't know about traffic, and that can actually move you up and over. But as you can see then, we're going to assume he's a criminal history category 1. Puts him right in the range of 87 to 108 months. That's roughly 7.5 years to 9 years in prison with a guilty plea. Now, I assure you, this is a conversation that Mr. Duggar's attorneys are having with him to explain the federal sentencing guidelines. He doesn't get that 2-point reduction if he doesn't accept responsibility and he takes the matter to trial. And like I said, the court can always impose the maximum sentence if they choose to do so. The defendant, Mr. Duggar, if he were to plead guilty, could also file what they call a motion for variance, which is basically, hey, judge, these federal sentencing guidelines used to be mandatory. Literally, when you went to federal court, you just kind of followed the numbers and wherever you came out, that was the range. And that was the range that the court had to follow. Well, the United States Supreme Court in a case said, no, you're taking away the authority of an Article 3 judge. They have to have some discretion. So this is just one factor, but most judges come out pretty close to this. And if not, they have to justify it really well as to why they did that. But the defendant, basically, then you have a good old-fashioned sentencing saying, hey, I'm a good guy, haven't really been in trouble, made a huge mistake, I'm getting treatment, I'm going to do everything I can, don't punish my family, blah, 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 blah. Then the court says, well, yeah, you weren't thinking of your family when you were off committing these acts, so that's really not a mitigating factor. I think one could actually say that's an aggravating factor because you didn't care about your family. Your potential addiction probably played a bigger role in it. So that is how Josh Duggar is going to be advised by his attorneys as to whether he goes to trial or enters a plea. And if he goes to trial, remember, all of a sudden now he's at 12 years and he can always be up to 20. So Mr. Duggar is going to have some hard decisions to make, particularly when your pregnant wife and 6 other kids are at home and who's going to take care of them. I'm sure his parents will, but more than likely, ladies and gentlemen, he's going away.
All right, straight to the docket. First thing, are Nicole Kessinger and Chris Watts back together again? Now, we all know Chris Watts. He's obviously serving a life sentence. He's never going to get out because he murdered his wife and 2 daughters, but it is reported that he is still in contact with his girlfriend that he killed his family to start a new life with back in 2018. Now, a fellow inmate, so you have to take this with a grain of salt, told the Daily Mail that Nicole Kessinger, who's changed her identity and disappeared, is following Watts' arrest and conviction and still writes him under a new name. Now, as you may recall, we tried to attend the name change hearing of Nicole Kessinger, but the court basically made it a private sealing, which is unbelievable in the state of Colorado, because the attorney said that there was going to be press there, i.e. Scott Reich, who just wanted to lay out the facts. Apparently, somebody probably should have known what name Nicole Kessinger is probably writing Chris Watts under. I'm sure all of those letters are being examined, everything that comes in and everything that comes out. So this inmate says that Chris Watts told him that she needed to speak to him to clear some things up. Really? Wow. David Carter, that's the inmate, and he was released from prison in February, and he told the news outlet that he wouldn't tell me exactly what she said. And once again, for those of you who don't recall, Watts was having an affair at this time of the murders and telling investigators months after he was arrested and convicted, his girlfriend never asked him to get rid of his family, but their relationship may have contributed to his decision to kill his wife and daughters. Now, Nicole Kessinger has done everything to cancel herself and to drop off the face of society. She's very difficult to find. We found her, and we weren't going to dox her, but the reality of it is she has changed her name, but apparently just can't seem to get over that Chris Watts guy. makes you almost think that maybe she has something on her mind, maybe something she'd like to tell the rest of the world. She always has an open invitation. All she has to do is contact CrimeTalk. We'll give her an open forum, but we will ask the questions that everybody wants to know.
Now, it's been nearly 2.5 weeks since the shocking June 7th homicide of Paul Murdaugh and his mother, Maggie, on their estate in Collington County, which is in South Carolina. The shooting has garnered national and international attention due to the Murdaugh's family prominence in the Palmetto State. Rumors and theories have been rampant as people wonder who killed Paul Murdaugh, who was charged in the 2019 boat crash that killed a young woman, and his mother, Maggie, and why they were killed. Now, following the double homicide, the 2019 boat crash that killed 19-year-old Mallory Beach is also facing new scrutiny. The South Carolina Attorney General's office is probing how police handled the boat crash investigation that led to felony charges against Paul Murdaugh. Law enforcement has released little information in the wake of the shooting, and as late as this weekend, no suspects or arrests have been publicly announced. But let's give you a quick timeline. Monday, June 7th, between 9 and 9:30 p.m., Paul Murdaugh and his mother, Maggie, die from gunshot wounds on their property. This took place at their hunting lodge in Islington. At 10:07, Alex Murdaugh, father and husband of the victim, calls 911. He tells dispatch he returned to the property and found 2 bodies. The Collington County Sheriff's Office deputies respond to the scene. Those deputies contact the South Carolina Law Enforcement Division to help conduct the investigation. That is known as SLED. SLED regional agents begin arriving to the scene and take the lead in the investigation. That was about 11:47 p.m. Now at 12:07 a.m., SLED crime scene agents begin arriving on the scene. They collect evidence and submit it to the agency's forensic lab. On Tuesday, June 8th, the South Carolina Law Enforcement Division, SLED, and the Collington County Sheriff's Office are investigating this double homicide at the well-known hunting lodge of the Murdaugh family. Early sources confirmed the victims were related to the Murdaugh family, but will not provide exact details. At 11:31 a.m., the Murdaugh's law firm releases a statement about the deaths on its Facebook page. This is the first public confirmation identifying the victims as Paul and Maggie Murdaugh. At 1:17 p.m., at the time of his death, Paul Murdaugh's felony charges were being prosecuted by the South Carolina Attorney General's office. A spokesperson with the office says, "We obviously cannot proceed with the prosecution, so once we have a death certificate or other acceptable proof, we'll officially dismiss all charges against Mr. Paul Murdaugh." At 3:45 p.m., the family of Mallory Beach, the young lady who died in the 2019 boat crash, releases a statement through their lawyer, and it states, quote, "The Beach family extends its deepest and warmest sympathies to the Murdaugh's family during this terrible time. Having suffered the devastating loss of their own daughter, the family prays that the Murdaughs can find some level of peace from this tragic loss. They would like the family and the community to know that their thoughts and continued prayers are with the Murdaughs. It is their most sincere hope that someone will come forward and cooperate with authorities so that the perpetrator of these senseless crimes can be brought to justice." On June 9th, the Collington County Sheriff's Office releases the initial police report from the double homicide. It is 1 sentence long and refers to a supplemental report that the department has declined to provide. Now, under South Carolina law, initial police reports must be made public within 14 days of an incident and must include details such as the nature and substance of the incident. The sheriff's office has also declined to release 911 recordings from the night of the shooting. At 2:50 p.m. that day, the state's top law enforcement officer of SLED, Chief Mark Keel, tells reporters, "We are pursuing all leads and the investigation is continuing." On June 10th, an autopsy was performed on Paul and Maggie Murdaugh at the Medical University of South Carolina in Charleston, and the full results will take 6 to 8 weeks to complete. Now, the Colleton County Sheriff's Office says it turned the investigation over to SLED because of a conflict of interest. At 3:10 p.m., it's determined, and despite the 3 felony charges against Paul Murdaugh being dismissed because of his death, the criminal investigation into the 2019 Beaufort County boat crash will remain active, according to the South Carolina Attorney General's office. At 4:40, sources familiar with the investigation confirm that one theory investigators are pursuing is the likelihood that Paul Murdaugh was targeted while his mother was killed because she was there by happenstance. Paul was shot in the head and upper body with a shotgun. Maggie Murdaugh was killed with what appears to be an assault rifle. At 6 p.m., the Hampton County coroners confirm Randolph Murdaugh III, the former state solicitor and patriarch of the Murdaugh family, dies days after the double homicide. Sources say he was ill at the time of his death. On June 11th, hundreds of people attend a celebration of life for Paul and Maggie Murdaugh at the Hampton Cemetery on Holly Street. One family member describes the two as well-lived and well-loved before rainstorms swiftly ended the services. On Sunday, June 13th, about 200 people attend the funeral services at the Hampton Cemetery for Randolph Murdaugh III. On Monday, June 14th at 11:45 a.m., the Colton County coroner, Richard Harvey, tells reporters Paul and Maggie Murdaugh were both shot multiple times. He declines to answer any further questions about the autopsy results. At 3:38 p.m., a local newspaper, the Island Packet, publishes an exclusive report that Paul Murdaugh had 2 previously unreported brushes with law enforcement while free on bond. Those incidents include a traffic ticket in May of 2020 for driving more than 15 miles per hour over the speed limit, and was fined for a minor boating violation earlier this year. Both of those incidents happened in Charleston County. On June 15th at 4:45 p.m., SLED releases their first public statement about the case, confirming that Alex Murdaugh discovered the bodies and called 911. On June 16th, about 10:35 a.m., Mark Tinsley, the lawyer representing the family of Mallory Beach, says police improperly tried to influence the 2019 boat crash investigation. At 1:28 p.m. that same day, SLED sets up a 24-hour tip line for people to call with information. That number is 803-896-2605. At 2:44 p.m. that day, the 14th Circuit Solicitor's Office, which stepped away from the 2019 boat crash investigation, refuses to say what role it played in the double homicide investigation, raising questions about a potential conflict of interest. On June 17th, the Murdaugh family's first interview since the murders, John Marvin Murdaugh and Randolph Randy Murdaugh IV, say strangers had threatened Paul Murdaugh before he was killed. That was on the Good Morning America show, where they stated that they didn't take the threats seriously, and looking back in hindsight, obviously they should have. That's midday that same day. Keep out signs and a metal gate in front of the Murdaugh's family property are put up. On June 17th, the Charleston Post and Courier sues SLED and the Colleton County Sheriff's Office for not releasing the public records related to the murders. On June 18th, another clip of the Murdaugh family's interview says Alex Murdaugh, Mallory Beach's family, and all occupants of the Sea Hunt boat that crashed near Paris Island in 2019 voluntarily submitted to DNA samples to investigators. Then it's revealed that Alex Murdaugh was authorized as a volunteer for the 14th Judicial Circuit Solicitor's Office. The Solicitor's Office still refuses to return any phone calls by inquiries related from the press. On June 18th, it's determined that the South Carolina Attorney General's Office had opened an investigation earlier this year into how police handled the 2019 boat crash investigation. A state grand jury is probing whether there was obstruction of justice during the investigation. Also that same day, SLED reports that they searched the University of South Carolina residence where Paul Murdaugh was living during his spring semester. And that's where we stand to date. Like I said, this family is very well connected, a lot of influence, and there was a lot of question as early on, since Paul Murdaugh was the driver of this boat, why it took so long for charges to be filed. I don't think it takes a whole lot of common sense to come to the conclusion it was probably because his last name was Murdaugh. I think it's interesting, and obviously the police have to do their investigation, that everyone that was on that boat where Miss Mallory Beach was killed in that boating accident submitted voluntarily to have their DNA taken for testing. It would make you think, and we try not to speculate, that the police are either trying to eliminate as suspects or look into all theories that maybe somehow this double homicide is related to that 2019 boat crash.
We here at Crime Talk sent Julie, our young producer, down there to get in line early so that she could be in the courtroom. And guess where she is? That's right. She was there at 6 a.m. this morning, the second person in line. So she is in the courtroom taking copious notes and tweeting via Twitter. So if you have Twitter, go to Crime Talk with Scott Reich there on Twitter. You can see her texts as they come through regarding what's taking place. Obviously, the big news of the day, it turns out a lot of people were suspicious of extramarital affairs in the Morphew matter. Apparently, Suzanne Morphew thought that Barry Morphew was having an affair, and as it turned out, that Suzanne Morphew had been engaged in an extramarital affair with someone that she has known from high school for at least 2 years. They have met at least 6 times over the last couple of years in various cities. Now, that's the big news that came out. I think the significant thing is from that was that, well, first, no one said anything about it. Second of all, that the gentleman who was having an affair with her didn't come forward to the police until they contacted him. He didn't come forward when learning about Suzanne Morphew's disappearance. There was news about the bicycle, the way it was found, no indication that there were tracks going to where something may have taken place, no scuffle, nothing along those lines. I told you that I thought when you have to use a 152-page affidavit to establish probable cause, there's something in there that is problematic for the prosecution. Now, this is early in the stage and the burden is low for the prosecution, but these attorneys for Mr. Barry Morphew are very, very good. I told you they're coming out swinging. They are going to try and win this preliminary hearing, which means a first-degree murder charge doesn't stand. We've got today, tomorrow, and then 2 more days in a couple of weeks. It's going to be interesting.
Now, the big story obviously out there is Gabby Petito. And I'm going to try to answer a couple of questions that a lot of people have been asking. First, can Brian, the boyfriend of Gabby Petito, remember he's the guy that returned home with Gabby's van, can he be arrested for stealing the van? The answer is possibly. One of the elements in any type of motor vehicle theft case is that you have to be able to prove that the person was unauthorized, didn't have permission to have the vehicle with them. Well, who are they going to get that information from? Gabby Petito. So no Gabby, possibly no charge, because all he would have to say would be, I had permission to have the van. Next question. Why didn't Gabby get arrested when the police were there? Why wasn't she taken to jail? Well, good question. Now, I am a firm believer that police should be allowed to use their common sense. Although Gabby was crying, and we'll talk about this more in a little bit, this is the reason why a lot of laws were put into place that if somebody makes a domestic violence call, then somebody has to go to jail once the police shows up. It's kind of a cooling off period. Whereas when you keep people together, they're always kind of possibly intimidating. No, of course not. I don't want them to get in trouble. And then it escalates when the police are gone. I think the police did a pretty good job of trying to de-escalate the situation. Hindsight is 20/20, and you think, oh, the police should have done this, they should have done that. But obviously, we don't want to over-criminalize everything. And if everybody's saying, hey, it's just kind of an argument, which is not illegal to do, it allegedly didn't get physical, even though they were locked out of the van. Most places, somebody's going to jail. I think the police officers here probably were exercising what they believe to be good judgment and tried to resolve it without having to send somebody to jail. They are not fortune tellers. They don't have a crystal ball. I don't think that people should necessarily be jumping all over them. I know I first thought, well, if they'd arrested this guy, maybe she'd still be with us. But when you look at the context of it, yeah, she's upset. I don't know. It's a tough call. I don't think the police did anything wrong in this particular case. All right. Now, the Moab City Police Department released body cam footage following an alleged physical altercation between Gabby Petito and her boyfriend, Brian Landry, just weeks before she disappeared. Now, we've uploaded the entire body cam video on our YouTube site. Go check it out. Now, the hour-long body cam footage shows the officers responding to a 911 call reporting an alleged domestic dispute between the pair on August 12th in Utah. A witness reported seeing a male had been observed to have assaulted the female near the Moonflower Community Cooperative, an organic grocery store. Petito and Landry then left the area in the van, but one of the officers, he was able to catch up to the van as it neared the entrance of the Arch National Park. Officers stopped the car for going 45 miles per hour in a 15 per mile hour zone. Officers noted that Petito was crying, and in their words, uncontrollably throughout the conversation, and Petito said that she was struggling with her mental health. Petito said she has OCD and anxiety, which can be triggered by stress. She said she was also working all morning and was having a little argument with Brian as well. Now, Petito told the police that she is the one that hit Brian in the arm to get his attention. Landry told officers that they had been traveling for 4 to 5 months, which has caused a strain on their relationship and increased the number of arguments that they had been having. Petito had gotten so upset that she thought Landry was going to leave her in Moab without a ride. This is according to Landry. The police took pictures of Landry to document any cuts or bruises he had and asked if he wanted the police to press charges. The police reassured Brian that couples get in fights and that they should take some time away from each other to get a shower and to cool off. Officers didn't believe that it escalated to a level of domestic assault and that it was more of a mental health crisis. Now, the father of 22-year-old Gabby Petito recently slammed Landry's family for not offering to help find his missing daughter. Brian Landry's attorney released a statement saying that they hope Petito is reunited with her family, but they'll be staying in the background at this time, and we have no further comment. To be honest, that wasn't a statement. Joseph Petito said in a press conference on Thursday, that was 4 lines of crap. But what do I know? If you honestly wish for her to come home already, then cool, let's sit down and answer questions. Gabby's father also said that Gabby had the entire trip with Landry planned out, day by day. She had an itinerary, and she did everything she was supposed to do. Gabby reached out to her family members during the entire trip, so when she stopped calling, that is when her father, Joseph, knew something was wrong. He says, you're going to stay in the background? You just traveled with this girl across the country, and you're going to stay in the background? That's according to Joseph Petito. Does anybody take that seriously, he said. Do you think they care if she's missing, if they're going to stay in the background? Now, Gabby's father is pleading with Brian Landry and his family to answer questions. Are we in the right spot? Help us. At the end of the day, if I don't have my daughter, it doesn't matter. But they're not helping. The tip line is open to anyone who may have information on the disappearance of Gabby Petito, and that number is 800-220-8477. This is definitely going to be an interesting case indeed. Why does Brian Landry have Gabby Petito's van? Did he have permission for the van? There's also a little bit of a coincidence that there was a couple that was murdered there in Utah that worked at the same co-op just a few weeks ago. Is it connected? I don't know. We're going to have to wait and see. Anything comes from this investigation. Since that area is so large and there's so many open spaces, where do you even begin? All right, let's get to the docket. There's been a lot of talk the last couple of days, and it's frankly, a lot of people are just going crazy over this, but there's this trucker. His name is Rogel Aguilera-Mederos. Well, he was sentenced on Monday to 110 years in prison for causing a crash on Interstate 70 near Golden, Colorado. And 4 people were killed on April 25th of 2019. Now, since his sentencing, a wave of support for Aguilera-Mederos is gathering online. A petition that has been set up for his name to offer commutation has been set up, and it's going to the governor. And these people want the governor to grant clemency to Rogel Lazario Aguilera-Mederos. All right, they've collected 2.7 million signatures. Now, Mr. Mederos is a Cuban immigrant and has contacts with the League of Latin American Citizens, and they are calling on the governor here in Colorado, Jared Polis, to pardon or to commute his sentence. Now, the league also says that it was working on registering a formal complaint of gross misconduct with the Colorado Bar Association against the 1st Judicial District, Alexis King, for abuse of power and official oppression under the color of law in filing charges against what they believe to be an innocent truck driver who was behind the wheel when his truck's brakes failed. Well, first of all, Alexis King wasn't the DA when the charges were originally filed. King's office has issued a statement, and it said the sentence, which our office requested the minimum sentence, is within the purview of the court and reflects the judgment of the legislature. District Attorney King also wasn't the person, as she stated, who filed the charges against Mederos. It was the previous district attorney, Peter Ware. Her official response notes that just as the law mandates this outcome, it also provides future opportunity to revisit the sentence. During Mr. Mederos' trial this past fall, prosecutors portrayed Mr. Mederos as a reckless individual, while the defense team cast him as a victim of numerous mechanical problems with his truck. Now, Mr. Mederos testified, and he considered several options when he realized his brakes had failed, including driving onto the grassy median that separates the eastbound and westbound I-70 lanes near what they call the Colorado Mills area or the mall. But he feared that he'd wind up in the path of oncoming traffic on the other side of the highway, and that smashing directly into the bridge would cause an explosion, according to his testimony. So he said he attempted to try to slow down by swerving, but unfortunately that didn't prevent the tragedy. Now, in the end, Mederos was found guilty of 27 of the original 41 charges against him. Included in the guilty verdicts were 4 counts of vehicular homicide, 6 counts of assault in the first degree, extreme indifference, and 10 counts of attempted assault in the first degree, extreme indifference. There were also 2 counts of vehicular assault reckless and 1 count of reckless driving and 4 counts of careless driving causing death. Now, Mr. Mederos told investigators his brakes failed, yet the district attorney in this case charged him with the first-degree assault and attempted first-degree assault. These are considered crimes of violence under Colorado law, and therefore they have mandatory sentencing convictions, which must run consecutively, which totaled the 110 years. Now, Mederos was not charged with driving under the influence, but the jury found him guilty of not using a runaway truck ramp when he passed it immediately before the fatal crash. Now, Mederos had testified that he did not see the runaway truck ramp or the signs. Ultimately, the jury found Mr. Mederos guilty. So what's the big issue here? Was this more than likely a vehicular homicide case, extreme indifference? What's extreme indifference? Basically, complete disregard for the safety of individuals. When you know your brakes are not working properly or going out, you probably should take reasonable precautions to not drive or stop immediately. And that's would have been the appropriate charge in my humble opinion. And obviously, Mr. Mederos was found guilty of those charges. But the district attorney, in typical fashion, overcharges the situation. They charged first-degree assault, First degree assault, extreme indifference, is basically that you intended, by your complete disregard of every situation out there. Basically, it's the equivalent of shooting a firearm into a crowded house. That is extreme indifference, and that's what the jury concluded in this particular case. Now, the jury could have found him not guilty, but they believed that there was sufficient evidence for the charge. All right. He was convicted. My understanding through plea negotiations and a statement by the district attorney was that Mr. Mederos would only consider taking a guilty plea to a traffic offense. Other than that, he wasn't interested in taking a plea bargain. So he went to trial and rolled the dice. Well, welcome to the judicial system, ladies and gentlemen. Can you blame the prosecutors? Maybe they could have not filed those charges if they thought that it was overkill, but they didn't. They let the jury decide. Can you blame the judge? Well, the judge was brought in as the visiting judge, and he imposed the minimum sentence of 110 years. Now, a motion to reconsider can be filed within 128 days, even on a case where there is a crime of violence. I can tell you, I don't think I've ever had one of those granted, particularly in a crime of violence case. The reality of it is, it's the court saying, hey, you don't like the law? Don't blame me. Go talk to the legislature. I'm just following the law, which is what judges are supposed to do. 110 years, I don't know. For the death of 4 innocent people, some people would say, not enough. Clearly, it's a life sentence. He'll never get out. Even under our sentencing scheme in Colorado, 110 years. Even on a crime of violence where you're supposed to serve 75% with good time, earned time credit, he'll probably get eligible for parole about 50%, which would still make him a very old man if he were to get out. It's good that Mr. Mederos obviously has people supporting him. That's a very good factor. His first attorney in this particular case, well, he was disbarred. He had some legal issues going on. He has another gentleman that was his attorney throughout the trial, a guy by the name of Jim Colgan. He's a former prosecutor. He bounced around a lot of district attorneys' offices and then ultimately has gone into private practice. It's unclear whether they had the financial resources to properly defend this case, where there were enough experts, so to speak, that could have testified that there's no way that this, in fact, could have been avoided. We will have to wait and see if the governor is going to do something. My guess is he's going to say he's going to leave it to the courts and maybe apply for clemency in the future. Just because somebody who people don't think should go to jail or prison in this particular case for a long time, like I said, talk to your legislator. Everybody likes mandatory minimum sentences until there's that one case where people think, wow, that seems really harsh. Or it's a family member, or it's a defendant who never thought that he'd be in this particular situation. All of a sudden, that seems a little harsh. So we get judges that are appointed here, and they're supposed to be there to make the hard decisions as to what case warrants prison and a lengthy sentence, and those that don't. But when the legislature takes that decision-making out of the judge's hands, this is what you get. Let me know what you think. Too much time? Not enough time? A lot of people have lots of opinions on this.